All right. We do have our next witness in the waiting room. I did want to note first, yesterday there were some problems with my video camera which prevented me from being visible to the parties during the testimony of Ms. Parham. I neglected to note for the record that we cured my camera problem for the next witness and for the remainder of the day, and my camera is working fine today so far. I just wanted to make that clear for the record. So we're moving on to the next witness, Mr. Chung, but let's take a brief comfort break first. So let's go off the record.
We are off the record at 10:36 a.m. We are back on the record at 10:43 a.m.
We have our next witness, President Bruce Chung. Mr. Chung, again, I am Administrative Judge Martha Russo, and I have been assigned to adjudicate this appeal. You have been asked to provide testimony in the matter of Sylviane Kouemo versus the Small Business Administration. While you're testifying here this morning, please answer all the questions orally and keep your voice raised so that we can all hear your testimony and accurately capture it for the record. In addition, if an objection is raised to a question while you're testifying, please wait for me to rule on the objection, and then I will tell you whether or not to continue with the response. I do need to swear you in before you testify, so if you would please raise your right hand. Do you swear or affirm the testimony you are about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may lower your hand. Mr. Chung, would you please spell your first and last names?
First name Bruce, B.
Hold on, Mr. Bruce, or Mr. Chung. I'm sorry. We've lost your audio, or we've lost your voice. So we're still not hearing you, Mr. Chung. I'm not sure if you can hear us. Somehow your microphone may have gotten disabled. No, we still can't hear you, Mr. Chung. All right, let's go off the record for a moment to try to work that out.
Yeah, I must apologize in advance. I tend to have this problem with my particular laptop on Zoom. It'll just periodically mute itself. So I do apologize in advance.
Okay, well, it seems like you figured out what the fix is, so just be ready to implement that if we start to signal that we can no longer hear you. Let's go back on the record.
All right.
We are back on the record, Judge.
Hold on, Mr. Chung. Okay, thank you. All right, so we've got Mr. Chung's microphone restored. So, Mr. Chung, if you would again please spell your first and last names.
First name B-R-U-C-E, last name C-H-E-U-N-G.
Mr. Chung, are you currently employed by the Small Business Administration?
Yes.
In what position?
I'm the Deputy Assistant Center Director of Accounts.
How long have you been the Deputy Assistant Center Director for Accounts?
Since February of 2020.
Thank you. All right, Ms. Kouemo. Ms. Kouemo, you're on mute now.
My apologies, Judge. I didn't realize I was on. Hello, Mr. Chung. How are you doing today?
I'm doing well. Good morning to you.
Thank you. Mr. Chung, I want to ask you, I'm sorry, am I saying, is it Mr. Chung or Mr. Chung?
Chung is fine. Chung.
Okay, yes. Okay, thank you. Mr. Chung, since you've been, before you were an assistant director at the SBA, I believe you say it started in February 2020. What was your role, or was that your first appointment at the SBA?
I started with the Small Business Administration in September of 2006 as an attorney advisor. In March of 2015, I assumed the position of supervisory attorney advisor. And again, in February of 2020, I assumed the current position that I occupy at this time, which is the Deputy Assistant Center Director of Accounts.
Thank you. And when you were hired at the SBA in September 2006 as an attorney advisor, actually, no, I'm sorry, I'm going to withdraw that question because I believe I got an objection for that before. So, would you please, if you are ready to do that, would you please open document tab number 9? And we are going to go, when you open the document, we are going to go to page number.
Okay.
We're going to go to page number 60. 60. Yes, it's 60.
Ms. Kouemo, I'm just going to remind you to make sure you keep your voice elevated. You're tending to fade off a little bit at the end.
Thank you, Judge.
60.
I want to ask you if you see the this is a conversation, an email conversation with Miss Miriam Solo, and I want to ask you who is Miriam Solo exactly?
She's the assistant to the department manager, Mr. James Rob Goodson, and myself in the accounts department, program assistant.
Okay. And what are her duties as far as timekeeping and leave go?
She helps us track a variety of different reports for the department, in addition to time and attendance. It may be production related and just general administrative functions.
Okay. You said attendance reports and also performance reports, I believe?
Not performance reports, just administrative, various administrative functions. When, for instance, she says in her email, if you do not have, if you see the highlighted portion, if you do not have accrued sick leave or are using annual leave or LWOP, you are not allowed to. Basically, that whole sentence. Yeah.
When she says that, when she says anything like that, when she sends these emails, is she speaking for management in general, or is that something she does on her own?
Yes, this conveys or communicates the general department policy.
Okay, thank you. Would this policy do you change the policy periodically, or is it the same policy throughout the year generally regarding sick leave and regarding leave requests and attendance?
The policies generally remain the same, but it is subject to change depending on the level of disaster activities, and from disaster to disaster, there are various procedures or policies that may change, but generally remains the same.
Okay. And would it be fair then to assume that when I was working at the SBA in 2020, the guidance that the PDC office or the accounts department office wanted us to have for leave and absence. I received that information through Miriam Solo's email. Would that be fair to assume to conclude that?
I'm sorry, I didn't understand your question. Would you mind repeating?
Yes, I'm sorry. I know I had some issues with the wording of that question. Would it be fair for somebody like me that worked at the SBA in 2020 to assume that when I receive an email from Miriam Solo regarding leave request and leave or attendance, that any other previous, unless she specifically says so, any other previous guidance is not being enforced at that time?
If I'm understanding your question correctly, yes. Emails from Ms. Soto is general policies and guidance for the department, and when issued by Ms. Miriam Soto, reflects the policies or any directives from senior leadership as well as the department.
Thank you for stating that so clearly.
Sure.
On page, if you scroll down to page 64,
okay.
The highlight part says towards the bottom that people that are running late in the morning due to things like connectivity issues should contact a team leader manager. And if no one, I assume you can read for yourself. But based on this email, would it be fair to assume that somebody receiving this email will believe that if they contacted their team lead, at least the team lead before the start of the day, if they had any issues connecting to work or anything like that it will be sufficient so that they will avoid the AWOL determination?
Objection calls for speculation, and the agency objects to the use of this document insofar as it appears to be altered by the appellant, specifically with comments.
I overrule on both grounds. Mr. Chung, you can answer the question if you could.
All right. This email provides guidance specific to the issue at hand. According to the subject line, this relates to computer or connectivity issues. There are instances where unanticipated incidents occur, whether it be power outages due to storms, natural disasters, or whatnot. So to the extent that this email states what it states, it is applicable to the limited circumstances indicated in the subject line, again, which relates to computer and connectivity issues.
Thank you for your answer, Mr. Chun. Can we go back up to page number 54?
Did you say 5-4?
Yes, 5-4, please. First, I would like to confirm with you that in the top section where it says reporting your time to your leads, do you confirm that by saying what it says in the paragraph before the last one, where it's highlighted, that if anybody has issues connecting in the morning, they can call either the lead or the manager, and that would be sufficient?
Sure, let me read this. If I may ask you to repeat your question.
Okay. Based on that that portion that you read, will it be fair to assume if anybody was receiving this email, would it be fair for them to assume that if they called, if they were having some type of issues logging on from home, if they called their team lead or their manager, they will be fine?
Yes, I read this as long as it's done as soon as practicable.
Thank you. And if you scroll down a little more, where it says arriving after your selected flex start time, and it says if you are 5 minutes late, you must submit a leave slip. And it says annual sick or LWOP.
I see that portion.
Okay. And also the sentence right below. Also, I want to also join. I want to join the two sections together. Where it says requesting, where it says annual leave or LWOP. Running late, traffic, weather, external logic rates cannot go past your scheduled 8-hour shift. Would you concur that anybody reading those parts and not seeing, if you scroll down throughout this email and not seeing any mention of a role, will assume that small absences, like if being 5 minutes late, will pretty much be covered by either annual leave or sick leave or LWOP, like it says here.
Now the portion in red that talks about annual leave or LWOP hyphen no OT allowed, that is indicating, the intention of that is to remind the staff that when annual leave or LWOP is used, that overtime per policy is not permitted. So that does not speak necessarily to whether or not annual leave or LWOP is granted. It's simply a reminder that if it's approved by the department, then the employee is not to work overtime.
Thank you for explaining that. And if you go up one paragraph, the portion where it says arriving after your schedule, your selected flex time, since it did not mention any type of AWOL notification, because it says if you arrive, if you are 5, 10, or 20 minutes late or something like that, would it be reasonable to assume that, generally speaking, if you are 5 or 10 minutes or late, you could request and be approved for annual sick. I mean, not sick because you're not sick, but annual or LWOP.
Yes. Generally, if we're talking about occasional tardiness, the department does recognize that it happens, and so in the occasional cases where employees are late, they simply have to request and put in a request for leave, whether it be annual sick and or leave without pay. But again, this is on the basis that this is occasional and not a pattern or routine.
Okay. Thank you. Did you provide any notice to employees between April 7th, 2020 and August 15, 2020 regarding the difference between regarding getting AWOL if like you just said somebody was every term you use is recurring it has recurring absences. Did you provide an email explanation as to what you would consider as being a recurring absence or an occasional one?
Well, those are case by case. During the training and the onboarding, new employees are given information about our leave and attendance policies. One of which is the need to seek and obtain pre-approval in most cases before taking leave. However, it's difficult to put out every single scenario in which case where leave may be considered able, because it is evaluated on a case by case. A 5-minute tardiness may not be the same as a 3-hour tardiness, or if it occurs twice, isn't the same as 3 days, 3 full days. And so we always do our best to evaluate each one of those on a case by case, fair and consistently across with all of our staff.
Okay, thank you very much. And when you say if it occurs twice, do you mean twice the same day, or do you mean twice the same year?
That matters. I mean, those two scenarios certainly matter. If it's twice in a year, would be evaluated differently than if it was twice within the same day. The one where it's twice within the same day may not be evaluated as favorably as the employee who had two, relatively short tardiness through the course of an entire year.
And what do you describe as being short tardiness?
Again, that's on a case by case. There is no, we do our best to evaluate it under all information and circumstances at that time. So there is no written guidance that 5 minutes or 10 minutes constitutes short versus extended. So an employee who may be 5 minutes late every day for 2 weeks will be evaluated under those circumstances, as opposed to someone who may be late 30 minutes one time over the same 2-week period.
Okay, so are you saying that you evaluate absences taking into consideration, based on the time period? So you basically look at the time period to determine whether somebody's absence was great or small. Is that what you're saying?
One more time, I apologize. Could you repeat that?
I'm sorry. Would the time frame that you look at when considering the duration, the significance of somebody's absence, is that a 2-week time period that you look at?
No. Again, it's not 2 weeks. There's nothing concrete or finite as to. When we evaluate this, we look at both in terms of frequency as well as duration of time in question. And so there is not a set period of time. We recognize that there are varying situations, and so we do our best to evaluate it both fair and consistently, but at the same time on a case by case.
Okay, thank you, Mr. Chan. When somebody takes basically is absent or is running late, when are they required to submit a leave request? How soon are they required to submit a leave request?
Generally require or expect employees to notify management within 2 hours of the start of their shift.
Okay. And as far as putting in a leave request in the system, after notification, after they have notified who they need to notify and they get to work, how soon after they get to work should they submit a leave request?
Again, we only ask that they notify us within 2 hours of their start shift. And again, that's only in situations where seeking and obtaining prior approval is not possible. When in most cases seeking and obtaining prior approval should be accomplished and sought by the employee. The 2 hours from the start of their shift really applies in cases where seeking and obtaining prior approval is not possible, or again, typically in an emergency situation that prevented them or made it impractical or impossible for them to obtain prior approval.
Okay. And what type of information do you require, or have you always required since you've been a supervisor? Since 2015 when you were a supervisor, what type of information do you require that an employee gives you in order to make a determination as to whether you will approve annual leave or any other type of leave? What type of information do you require?
Not sure how to answer that question because it really, again, depends on the leave being requested by the individual employee and the circumstances.
Okay. What about annual leave?
Same thing. It depends on the extent of the request and how much notice we're being given. So there's a variety of different circumstances that it's difficult, if not impossible, to answer a set, process or set type of documentations or information we require. Most, if not all of these, are always evaluated on a case by case, applying a fair and consistent standard.
Okay. Can I ask you to pull up page 67, please, for the same document?
Okay.
If you read the highlighted portions, please.
If you take an extended lunch, meaning...
No, I'm so sorry, Mr. Sean. I'm meant to read it to myself. I don't want to bother the...
Oh, sure, okay. Okay.
Okay. Would it be fair to assume that if somebody read that email, that they will believe that if you are running back late from lunch, for instance, you could submit and be approved for annual leave or LWOP for, like it says on page in the middle. Towards the bottom of page 67, if you are 5 minutes late, you must submit a leave request for 15 minutes. Do you have any indication based on this email that somebody reading it would think that they will be charged AWOL if they were 5 minutes late after lunch?
Objection calls for speculation and the document speaks for itself.
Overruled. You can answer, Mr. Chung.
The information on this, we build in flexibility, recognizing that there are going to be situations and times where things happen that would prevent an employee or any staff member from returning back from their lunch break on time. And that's the purpose of this. It is not intended, however, to allow employees to abuse and again, if it becomes a pattern or it becomes excessive, to continue to run late from lunch. That is covered separately again during the training and the time and attendance portion of the onboarding for employees when we discuss expectations about time and attendance. Is that while we try to be flexible and recognize that there are times when extended lunches are necessary beyond for circumstances beyond an employee's control, it is not intended to be abused.
Thank you, Mr. Sean. So if we please go to if we open, actually, same document, page 125, please.
Okay.
And if you scroll down to page 126, I just want to make sure that you remember our conversation regarding my appeal of the AWOL determinations that were made on me.
Yes, I do. Yes.
Okay. Thank you. Do you recall the circumstances surrounding the actual absences and the actual leave requests that I made? Do you recall why I was 5 minutes or 15 minutes late, or 1 hour, or 2 hours?
Yes,
Okay,
I do recall the general circumstances.
Okay, thank you very much. So I want to ask you, what, if you don't mind stating for the record, what was your decision for denying the 2 15 minutes leave requests that I made? I'm sorry, for denying the appeal of the let's start with the 2 15 minutes annual leave or LWOP request that I made.
Now, the evaluation of this, when I looked at this, wasn't isolating the 2 incidents regarding the lunch break or the additional time to return from lunch break. Evaluating this, I looked at all 4 incidents in its totality, not separate or isolated from each other. Again, because these were 4 instances that occurred in a relatively short period of time within a single pay period, that was taken into consideration in coming to my decision to uphold the supervisor's decision to charge all the incidents as AWOL.
Okay. Thank you, Mr. Shan. Can I ask you, if somebody is absent for 15 minutes on one day, when does that person actually become AWOL? Basically, assuming that the determination was correctly made, when does the AWOL status basically applies as far as management is concerned? Is it on the day that the event happened, or is it at the end of the time period?
We can evaluate that. There is no set time in which we must render a decision whether it's AWOL. It certainly doesn't have to be the same day. We try our best to, again, evaluate everything fairly and consistently. So there are moments where we take time to make sure all information is carefully considered.
Okay, thank you, Mr. Shan. Do you have? Is it your belief? Do you believe that the information that you provided surrounding AWOL and surrounding frequency or things that, or simple frequency absences or durational absences, do you believe that it was clear enough for everybody to understand?
I'm sorry, can you?
Yes, do you believe that the information that you sorry about that?
That's okay.
Okay, I want to ask, do you believe that the information that you as manager provided to people in your the new team members for the COVID-19 pandemic, do you believe that that information was sufficient for somebody to know how the annual or LWOP leave requests were being evaluated, or whether there will be frequency or the time period or something like that will have any weight on whether that request will be approved or not?
I do believe that we communicated, reinforced, and reiterated, from the moment of onboarding new hires and periodically, whether it be through announcement from Mr. Goodson when he sends out periodic accounts department updates, or whether meetings are held with the lead, we continually reiterate time and attendance. As it relates to this matter, we do focus and remind staff that leave, again, generally has to be sought and pre-approved prior to the employee taking leave. And I do believe that that is made clear and communicated to the staff, again, from the moment of onboarding throughout their tenure with the agency and the department.
And how besides the emails that we've seen, do you believe that there were other communications that were dispatched from managers, from account managers to the staff between between April and August 2020 that addressed specifically AWOL or denial of annual leave?
I can't say or recall specifically what in those accounts update that is sent out by Mr. Goodson, but it does clearly state and reiterate and remind the staff that leave needs to be pre-approved, that employees need to seek and obtain pre-approval for their leave.
Thank you, Mr. Sean. And I would like to ask you, when you denied my appeal for annual leave or LWOP, were you aware of the fact that I had worked at the PDC for I think about 4 months at that point?
I was not aware specifically how long you have been on board.
Okay. So would it be fair to say that you did not consider any my attendance before the time period that was in concern, that was of the AWOL determinations?
In this particular situation, again, there are times when, whether an employee may have had great attendance leading up to a particular point in time, if all of a sudden the time and attendance becomes an issue, that weighs heavier and is taken into consideration. So if an employee's had no attendance issue in the previous year, but suddenly over a short span of time exhibited disregard for time and attendance policies, and it increased in frequency in a short period of time, that's something we consider. And for this particular matter, it was 4 incidences, again, within a very short period of time. So while it may matter, what the attendance was prior, here this was 4 instances within a short period of time, a 2-week period, and that's what I looked at, and that's what I considered in arriving at my decision to uphold the AWOL.
Okay. So would it be fair to say that if I had worked for 10 years at the agency and I had perfect attendance record, it would have made a difference in your determination? In
the scenario you described, I would not be able to rule out that an employee in that particular situation would not be charged AWOL as well. Again, given the number of frequency in a short period of time, does not negate or exempt an employee from being charged AWOL if suddenly attendance issues popped up.
Okay. And do you always address attendance issues, what you identify as being an attendance issue, by making sure that the person gets an AWOL?
No, we encourage the supervisors, and we ask that the supervisors, talk to the employee, let them know. We don't go straight to AWOL. We take AWOL very seriously. It's not something we like to charge employees with. And so we do take that seriously. And so we discuss time and attendance, and we routinely reiterate again our expectations and policy relative to time and attendance.
Okay. Is AWOL determinations, how is that, retrospective? No, I don't want to say retroactive. I'm sorry.
No, that's fine.
I want to say retroactive.
Are you asking if charging an employee AWOL can be done retroactively?
Yes, meaning that if on day, say, the time, I would say that if for 10 days or if the first 10 days, for instance, somebody was favorably being considered for an approval of an annual leave request, and then on the 11th day they had an issue with attendance, or they had something that came up and that you did not recognize as being valid for an annual leave, the approval of an annual leave request, would you go back and look and see what other instances you could charge them AWOL with?
It's within the management's discretion and entirely possible. If an employee called in or was late one day on that very first day, and let's say the employee was late 30 minutes, the supervisor may say that's fine, again, because it was an isolated incident. But if the employee proceeded to repeat that several times more in the course of that week, it then changes the evaluation of all of the attendance for that week.
Okay. And do you believe that that information was transferred to the staff clearly?
I'm sorry. What was?
Do you believe that the retroactive manner in which AWOL could be applied? Did you inform the staff at the PDC specifically about how you would AWOL?
It's informed in the sense that employees are communicating the expectations that they report to duty on time and report to work on their assigned days and time schedule.
Can I then assume that the answer will be no, you did not. You did not inform the staff specifically about the retroactive nature of the AWOL determinations?
Not in the way you specifically phrased it, but the employees are told, and we do have instructions and directions out to them, that repeated disregard for time and attendance policies and time and attendance policies could result in disciplinary action.
Okay. And do you believe that when you say disciplinary action, do you include AWOLs in among those disciplinary actions?
Not necessarily. AWOL in itself is not disciplinary in action. Now, it may form the basis for disciplinary actions, such as a reprimand, suspension, or removal or termination from federal service. But AWOL in and of itself is not necessarily a disciplinary action. It could form the basis for one.
How many AWOLs will justify starting a disciplinary action against somebody?
Again, that's a difficult question to answer, because it's not necessarily the number of AWOL. It also has to be evaluated in terms of the duration of each incident.
Okay. And how long will an incident have to be for AWOL in order for it to be justification enough to start to have a disciplinary action against somebody?
Again, there's not a bright line number in terms of AWOL, whether a certain number of hours or a number of incident where one is charged AWOL. There's typically far more, there are other circumstances that may come into play, i.e. there may be other issues, conduct issues, there may be insubordinations that would factor in with AWOL, and AWOL is just one of several factors. And so I can't answer your questions as to is there an exact number of AWOL instances or the amount of AWOL hours accumulated that would warrant disciplinary action, much less what level of disciplinary action, because we evaluate each employee with the information available to us on a case by case.
Okay. Thank you, Mr. Sean. Mr. Shaw, if you open, if you have document, do you have document number 10 open?
Tab 10?
Yes.
Give me one.
I did not remember whether I had asked you to open the document or not.
All right, tab 10 is open.
Please go to page number 87, please.
All right.
On page 87, if you see at the time, if you look at the date, that was June 6, 2020. As you can tell from this email, Mrs. Letitia Kwan was my team lead at the time because she wasn't the supervisor yet.
Yes.
I notified I was running late from work and I had some issue.
Ms. Kouemo?
Yes.
Ms. Kouemo, you're not testifying, Ms. Kouemo. Is there a question for this witness?
Yes. So if you scroll down,
Okay.
you're going to see the text message that I sent to Mrs. Kwan. My question to you would be, was that type of notification about me running late for work for the reason that I stated be sufficient enough for me to avoid an error or any type of denial of my leave request that day?
Under the circumstances, as I'm reading here on this screen, yes, it would have been fine to accept the request for annual leave.
Okay, and that was because, if you want to please elaborate a little bit on that.
I'm sorry?
And why was that okay, in your opinion, please?
Because the employee in this situation provided us context to evaluate the reason for having signed in or logged in later than their scheduled shift. And it was done so again within 2 hours of their shift. And without further context, I don't know. I don't know if this was the first isolated incident. I can only assume so. If in that case, again, it would be appropriate to approve the employee's request for leave.
Okay. Would you please scroll? I'm sorry. Let me make sure that Okay, Mr. Sean, please don't close the document number 10, but can we go back to the document number 9 real quick? And yes, please. And open page number 95.
Tab 9, page 95.
Yes, please.
Okay.
And if you scroll down to, if you would like please to scroll down to page 1 or 2. I mean, I'm just trying to refresh my memory as to this specific incident.
Okay, so what page on tab 9 now? Did you say 102?
Yes, I'm just asking you if you could please scroll down to page look at the conversation from 95 to 102 just to refresh your memory.
Objective is her question.
Yes, I'm sorry. I'm just asking the witness to base his information on those documents, and I'm going to ask the question next.
Overruled. I think Ms. Landry, she's just asking him to refresh his recollection using these documents, and then she'll pose a question.
Yes, Your Honor.
Okay.
All right, I've scrolled 95 through 102. This is the first time I'm seeing any of these documents, so it doesn't necessarily serve to refresh my recollection because as I've never seen these, or I do not recall have ever seen these documents.
And if, can you please look at 110 to 111, please?
All right, I've looked at 110 and 111.
And based on the documents that you've seen, do you understand what the context of what the emails were about? The emails that you just looked at.
No, the emails that I just scrolled through again, I had never seen those emails before. And as for 110 and 111, I have not seen either slides either until now.
Okay. Is it then your testimony that you were not provided, that I did not provide any of that information for a request of the 1 hour that I requested for annual leave, where I mentioned conversations with SBA colleagues in the office?
I was not provided these either from my supervisors or from yourself in your request for appealing the AWOL determination.
If we go back to page 125 of the same document, please.
Okay.
I want to make sure that, I'm sorry, before I point you to a document, I want to make sure that I have the information I'm looking for. Just a moment, just click on it, please. Okay, and if you scroll down all the way to okay, I'm sorry, I think I'm going to have to skip that question because I don't see the, sorry, I thought I had the documents here, but I don't have them pulled up. So I don't have them in this email, in this document. Can we go back to tab 10, please, and look at, I'm sorry, before we move on, if you have received those documents, would you have supported an annual leave request for that specific instance of taking 1 hour to talk to colleagues in another office about SBA matters?
I would need a little more time to read each and every single one of them, being that I have not seen them before, to fully understand the nature of the circumstances.
Okay, thank you. And if I told you that the conversation based on the document, those documents, the conversation was for about 15 minutes or so. It was about reconsideration for EIDL loans and the process of reconsideration for EIDL loans. And for the remaining 45 minutes or so, it was about general SBA loans, basically other non-disaster loans, but other loans and other SBA programs that those colleagues were working on. And if I also told you that at first when I requested, when I contacted those people in the other office, it was based on the newsletter an SBA newsletter that we had received at the office that indicated that those colleagues had concluded a training on reconsideration, and I requested just a 5 minutes conversation with them, meaning I didn't plan on spending 1 hour on the phone with them. Would that have changed your, would that have, based on that information, would you have granted, if you were my supervisor, would you have granted annual leave for that hour?
Again, without reading in detail each and every one of those tabs and slides, I can't comment. What I can say is that the information I was provided by the supervisors as well as yourself had indicated that the call eventually went into other things, and that the other person that you were talking to on the other side of the line had indicated to you that it should not and cannot be charged as agency time. And that's what I evaluated, and that's where I put the weight in evaluating that particular incident with the 1 hour phone call, is that in your email you had indicated that while the call started off as intended to discuss SBA related matters, it eventually led off into something else entirely. But you did not elaborate or provide detailed information or additional context.
Okay, I'm going to move on to tab number 10, please. Page 92, please.
92?
Yes, please.
Okay.
And I believe you were still an attorney, a supervising attorney in 2017 at the PC, right?
That is correct.
Okay. And if you look at page 92 to page 98,
All right.
okay. For instance, if you look at page 95, when it says remarks, it says 1 hour accrued annual leave, requesting 1 hour accrued annual leave, and it's from 12:40 to 1:40 p.m. on December 26, 2017. And then on number 6, it says remarks, long lunch.
Yeah.
Would you be surprised to see that that request was approved by my supervisor?
Objection relevance.
Well, Mr. Chung, did you play any role in the approval or denial of this leave request?
I do, given that this is back in 2017 and there's no signature on here as to who approved it, I can't say. I don't know if I was involved or not.
Okay. Do you have any recollection of her ever appealing any issue related to this leave to you?
No.
All right. I don't think this witness is appropriate for this question, Ms. Kouemo, so I'm going to sustain that objection.
Okay. Thank you, Judge. Can we move on to document number 23, please?
Tab 10?
I'm sorry, I keep saying document numbers, but I meant to say 37, not 23, but 37 first.
Tab 37?
Yes, tab 37, page 25.
Okay.
This is an email from, and I think we're going to scroll down a little bit, but I would like us to scroll down to, say, page, when I say scroll down, I mean look through the conversation to those in those pages.
Okay.
To, page, we're going to go all the way to page 38, but I just wanted, first of all, to make sure that you remember the events that took place surrounding these issues.
Okay.
Okay. Can I ask you if you remember who initiated the talks or the discussion within management as to whether to terminate me in 2020?
I don't recall who or how that transpired, but I can speak to our normal process. Usually if there are performance or production with an employee struggling with their performance or production, we ask that supervisors talk to the employees, give them an opportunity, number one, put them on notice so that they're aware of areas where they may be struggling and give them a reasonable time to improve. And having looked at this email, it appears that there may have been some areas of performance that may have been identified by the supervisor, and so we wanted to make sure that the supervisor did communicate that to the employee.
Okay. So did that have anything to do with the safe performance, but did that have anything to do with also attendance?
They're looked at and evaluated separately. As I indicated earlier, it's not uncommon for employees where we're evaluating multiple issues and they're not necessarily separate or apart. We look at totality, and so you may have an employee where we are evaluating time and attendance as well as performance or insubordination or a host of any other things. And so in this particular case, based on the information we were provided by the supervisor, it appears that we were looking at both a issue with time and attendance as well as possible performance.
Okay. Thank you, Mr. Shan. Do you recall what type of information you were provided from the supervisor on performance issues, on any performance issues that I had?
Only the summary that we're looking at here in one of the slides that's described by Supervisor Erica Rivera.
Okay. And generally speaking, do you make the termination, do you start termination talks, or do you make determinations solely based on what the supervisor says about someone else?
We take that in consideration, but that is not the supervisor. Ultimately would have to consult myself as well as Mr. Goodson. And before we take any such action, we always consult and confer with our employee relations group.
Okay. In conferring and discussing termination, do you look at any documentation or any data at all before moving forward, or during your assessment of whether to of the person's work or whether to terminate that person? Do you look at any documentation or any data whatsoever?
Our supervisors do, and we rely and we trust and we lean on our supervisors to do a fair and consistent, accurate assessment and evaluation of each employee's performance.
What type of data or information do supervisors collect to make those determinations?
I don't know all of the different databases. Just provide background at during this time. The agency was responding to an unprecedented level of disaster loan activity necessitated by the COVID-19 pandemic. And so many processes as well as systems had to be adopted and implemented and put into place to react and respond and to service the unprecedented number of disaster survivors that came to the SBA for assistance. And part of that change was the use of a third-party vendor and their system to administer the COVID Economic Injury Disaster Loan Program. Part of that vendor system, there were issues that we could not anticipate having come up, and as it did, we had to pivot. We had to implement manual processes quickly and rapidly as possible to resolve, address, and to prevent further issues. And so at this time in 2020, from the commencement of the COVID-19 pandemic, and now as we continue to work through and offer assistance with COVID idols, a lot of different processes, a lot of different teams, groups, projects were stood up in order to meet the incredible demand and the many issues that came up and identified that could not again have been anticipated because we were working entirely in a new vendor system. And so I cannot speak to the various and the multitude of different systems reports that our supervisors had the challenge of working in, creating, developing, monitoring throughout the pandemic.
To summarize what you just, not to summarize, but specifically of what you just said, are you also saying that, are you saying that for instance, supervisors like Mr. Martin and Mrs. Rivera during my time at the SBA in 2020 may not have kept track of my performance?
No, I'm not saying that. I'm saying you asked if I knew what report or what was being used to track. I don't know specifically which database, which spreadsheet, by what means. I do know it was being tracked by our supervisors, respectively in your case, Mr. Martin as well as Ms. Rivera.
Thank you, Mr. Sean. And as a manager in the department, do you still have meetings with supervising attorneys to discuss their work, to discuss their duties?
Can you rephrase or restate that, please?
Yeah, Ms. Kouemo, I think, hold on, Ms. Kouemo. I think at this point we need to focus specifically on the issues in your appeal. So I'm not quite sure where you're going with this, but if you could get to the issues that are in your appeal and ask him a specific question about that.
Okay. Thank you, Judge. Based on the email conversation that you just read, on page 30, there's a July 24 email where you say that, let me quote that, so I start quoting quickly. On page 30, where before I asked the question, was Mrs. Felicia Izobigi the contact at the ODC? ODSEE, okay, that you reached out to discuss this matter?
Correct. Ms. Izobigi is part of our employee relations group, part of OTSI, which is the Office of Disaster Strategic Effectiveness and Efficiency. And so, yes, she was the individual in that group that I was consulting, myself, Mr. Goodson, as well as Mr. Martin and Ms. Rivera. We were all consulting with Ms. Felicia Izobigi.
Okay. And on page 30, where you say that you you informed her that you were holding on termination for now. What was your decision to end talks about termination based on?
When I followed up and discussed with my supervisors, Mr. Martin and Ms. Rivera, it was my understanding that while there may, in their assessment, been some performance issue, it may not have been communicated to you at all. And so based on that, I had indicated to them that we cannot terminate an employee again without applying the consistent standard we've always applied, which is we have to let the employee know of areas where we feel they're struggling with and give them a reasonable time to improve.
Thank you very much. And if you go to page 38, okay, is that basically the conversation you were discussing moments ago regarding informing Mrs. Rivera and Mr. Martin on holding off on termination at this time?
That is correct. That is correct.
And in this email, please go ahead. I'm sorry, I interrupted you.
No, saying that this email again reflects what occurred. I followed up and I did the due diligence in speaking with the supervisors to determine what did or did not or has not occurred yet as it relates to any performance issues. Upon learning that the supervisor had not yet counseled the employee, I directed and advised them that termination is not the correct or appropriate action, and to have them make sure that they communicated that to you in terms of any areas of performance that needed improvement.
Okay, thank you very much. And if we go back to page 30, I just realized that I forgot to ask you to scroll down to the bottom of that page. And I was going to ask you, in this email, Mrs. Izabigi says, did you decide to work in a charge with AWOL? Did you talk to Mrs. Felicia about whether you were considering not charging me with AWOL?
I don't recall the specifics there from this email. My recollection is Mrs. Biggie was just following up. She wanted to know the status as to what decisions the department had made, and I was still evaluating your request or appeal on the AWOL determination.
Okay. And if we can open, please, document number 37. Is that the document we have? Yes, actually, that is the document we have open. So, still in 27, can we go to page 41, please?
41.
Yes, please.
Okay. All right.
This email, as you can see, is from Mr. Michael Greeley,
Yes.
or Mr. Goodson and you, and Mr. Garland. Can you please explain who the other people are? Who each person is, and how they relate to one another as far as hierarchy goes?
Sure. Mr. Goodson is my first line supervisor, Mr. Greeley is my second line supervisor, and Mr. Garland is my third line supervisor.
Okay. And that conversation happened on July 22nd. Am I correct? 2 days before the conversation that we just saw with Mrs. Izabiki. Is that correct? Okay. And if you remember also, this happened, July 22nd was a day, and this is at 8 a.m. That was a day after I had introduced my annual leave request to you, right? Actually, issue school. You don't even need to use your recognition words because you can just scroll down, and then there's an email from me to the four of you asking you to reconsider my denied leave.
Yes.
And in his email, Mr. Greeley said that that we've been working a lot of long hours and some measure of reasonable flexibility can be considered. How did you interpret the Mr. Greeley's input into my request for reconsideration?
Exactly as he stated, was a measure of reasonable flexibility, but taken again in context is the frequency as well as the circumstances surrounding it. The one incident where the employee was 2 hours late reporting for work, and we have given opportunities to provide us information, not even documentation, but just some kind of information context for us to evaluate whether the 2 hour late show was in fact an emergency situation. At that time, we had a staff of anywhere between 2,000 to 3,000 federal employees and contractors working within the accounts department, and to effectively and efficiently manage an operation with that large a staff, we had to again maintain a level of consistency when it came to attendance and policy. And so while Mr. Greeley did indicate that flexibility should be considered, we did just that. We did consider flexibility, but taken in its totality within a 2-week period, in a number of instances, as well as the failure to provide us any information to adequately evaluate one of the incident, we took all of that into consideration in the decision to uphold the AWOL determination.
Okay. Would you please hold on to page 42, please?
Okay.
Did you receive this email from Mr. I suppose you received it because you assisted in that email. Did you read it, or back then? Do you recall seeing this email? That's what I want to ask. From July 21st.
I do. I recall this email.
Okay. What I'm reading is that the Odyssey contact that you reached out to stated that the leave requests that are made qualified as leave without pay. Why did that not make any? No, I'm sorry, I'm going to ask you, did that Odyssey recommendation or advice play any role in your denial of my appeal of the leave?
Yeah, we consulted OTSI. We considered their recommendation. Ultimately, OTSI is an advisory, plays an advisory role, and when I looked at the totality of the circumstances and the information I was provided by yourself as well as the supervisor, I made the determination that because of the 4 incidents in a single pay period, as well as your refusal to provide us context to evaluate one of the more significant incidents, taken as a whole, that formed the basis for my decision to uphold the decision, to uphold the charge of AWOL for those days.
Mr. Chen, hold on. Mr. Chen, could you clarify for me, what is ODSI?
ODSI is the Office of Disaster Strategic Effectiveness and Engagement. They are the Office of Disasters Assistance Employee Relations Group.
Okay, thank you.
You're welcome.
I'm going to ask you, Mr. Shan, if you will please put up tab number 23.
Okay.
Actually, because you, before we do that, can I ask you, Mr. Chen, did you advise my supervisors to issue a letter of counseling to me because of
No.
this? Okay. Okay.
Not that I recall.
Okay. Then we don't have to do that part. Thank you very much.
Okay.
I would like to ask you, Mr. Shen, how many attorneys did you, if you, roughly how many attorneys did the PDC office hire as contractors or permanent employees, not permanent, but contractors or direct hires for the COVID-19 pandemic?
I would not know the number, the breakdown between legal assistants, paralegals, and attorneys. I just know there were a lot of each categories. That information may be available for our personnel department.
Okay. Would it be fair to say that around June and July 2020, that the PDC office was aggressively hiring attorneys to handle the EIDL loans?
We were aggressively hiring in all categories, attorneys, paralegals, as well as legal assistants.
Okay. How long, if you can speak as to this, how long will it take for somebody that is newly hired to get on board and start producing at the level of somebody that has been on the floor, generally speaking?
Objection or relevance.
Yeah, sustained. Ms. Kouemo, could you ask a question directly related to your appeal, please?
Yes, Your Honor. Thanks. Sorry about that. Thank you for reminding me. Mr. Strong, can you, if you still have tab number 10 open and we go to page 115, please.
Sure. Give me 1 second. All right.
Did you have anything to do with recommending or approving my promotion to high grade?
Objection or relevance.
Ms. Kouemo, you proffered this witness during your pre-hearing submissions to testify regarding your performance and the AWOL determinations that you received under his leadership. I think he's spoken on those topics, so I didn't approve him to testify on matters beyond that. So it seems to me that you're exceeding the scope of what you proffered this witness for. What information are you seeking now that has to do with those topics?
Yes, Your Honor. I just wanted to point out that on July 5th, I received a suitability, a conditional offer for promotion to higher grade, and I believe that such promotions take into consideration performance and general attendance matters and things like that. And then that conditional offer became solidified, or became I was actually promoted in late July after the AO determinations. So I want to ask Mr. Shen whether why, despite reaching out to ODC and exploring the possibility of terminating me, I was approved for the promotion, and then also what role the AWOLs play in such evaluations for suitability or to move up to higher grade.
Well, I don't see the relevance of those issues to this appeal, Ms. Kouemo. The fact is that you were promoted, so there's no issue about a denial of promotion being an adverse action at issue here. So I'm going to sustain the objection on the grounds of relevance. So you can move on if you have more questions for this witness.
I believe that I've asked. I'm sorry, Judge. There are a couple more questions. Mr. Chan, how are you aware of ways that remote employees, like I was back in 2020, what type of systems they have access to, and whether those SIPs, no, I'm going to rephrase that question, I'm sorry. Can you confirm, Mr. Stern, that for people working remotely from home, for instance, during the disaster in 2020, that they have to use their cell phones to connect to the SBA system in order to call borrowers?
Objection relevance. Sorry.
Okay, thank you. Ms. Kouemo, why is that relevant?
It's relevant because I'm trying to establish the fact that that we had to use our cell phones to connect, and that we were not necessarily using the SBA system to call. I mean, we were not using embedded SBA tools for applicants, and there were issues, for instance, when the connection will not, the disconnection after work hours, for instance, or during the work day will not work as well as it would have worked. Therefore, it could be, for instance, that IT security or any other people who have access to our phone calls, basically to our own private matters.
Sustained. The objection is sustained on the grounds of relevance.
Okay. I believe that's all for now, Judge.
Okay. Ms. Landry, do you have cross-examination?
I do, Your Honor. Just briefly, please. Mr. Chung, good afternoon. Could you please explain briefly for the court what the leave restrictions that were in place for the Processing and Disbursement Center in summer of 2020 were?
Sure. At that time, again, we were in the midst of responding to the unprecedented disaster created by the pandemic, the COVID-19 pandemic. Over a course of several months, we onboarded thousands of federal employees as well as contractors to meet the unprecedented demands for disaster loans to businesses that were suffering as a result of the pandemic. And so we were all on mandatory overtime. Employees who were hired were put on notice up front that we were working 6 days, 10-hour days, and those were mandatories. And because of the exigencies of the loan volumes, that we simply weren't in a position to allow or approve much leave outside of medical or medically necessitated leave. And that's what we did. We applied it consistently throughout the entire department, regardless of positions or what area they were working, given, again, the large volume of loan activities we were trying to respond to.
Thank you. And am I correct in that if an individual had unapproved leave for a day and was, I'm sorry, let me rephrase that. What kind of situation would lead to someone being unable to work mandatory overtime?
Generally, it would be medically necessary. If they had procedures or they were ill. Obviously, if they were diagnosed with COVID. So in those situations, of course, we approved and allowed leave. What was restrictive was primarily vacation time or personal time off, unrelated to medical or sick leave.
And you recall sustaining the decision to charge the appellant with AWOL in this matter, right?
Yes.
And you previously testified that you considered the AWOLs on a case-by-case, fact-specific basis, right?
Yes.
And you did that for the appellant's AWOL charges, correct?
Yes.
Now, isn't it true that appellant failed to tell you the exigencies or any circumstances behind the personal emergency that she took for 2 hours one day?
That's correct. We asked on several occasions, and we gave several opportunities to provide us. We wanted, again, we took her request seriously. We wanted to seriously give it fair consideration, but to do so, we needed information. We needed context to evaluate whether it constituted a true personal emergency. And after several requests, we were not provided any information to do so.
If the appellant had told you that she needed that leave in order to apply for a job position not within the agency, would that leave have been granted?
Generally, no. And secondary to that is, if that's what, I'm assuming if that was the reason for the 2 hour late start on the day in question, that would not have been sufficient basis for not seeking and obtaining pre-approval. I would consider that something that the employee would have known in advance and had opportunity to obtain pre-approval, as opposed to notifying us after she's already taken the leave.
At the time that you sustained the AWOL charges against the appellant, you didn't have any knowledge of any disclosures or communications by the appellant about rules regarding the EIDL loans, did you?
No.
And at the time that you sustained the AWOL charges against the appellant, you did not have any knowledge of any disclosures or communications by appellant regarding an IRS Form 4506T, did you?
No.
And to confirm for the court, the appellant was not terminated from her job, is that correct?
That's correct. She resigned.
And how do you know that the appellant resigned from her job?
I was copied on an email regarding the employee's email to, I believe it was her supervisor and or personnel notifying the agency of her resignation.
Do you have any reason to believe that the appellant's resignation was anything other than voluntary?
I had no reason to believe that.
No further questions from the agency.
All right, Ms. Kouemo, do you have any redirect?
Yes, Your Honor, I do. Please. Mr. Sean, would you please open document number 10? Again, page, let's go to page 31, please.
Okay.
Beyond the information that I provided, beyond information I provide in these emails to you and to managers, what other type of information would you have required for the approval of my leave request for being late or for being late after lunch or things like that? What type of information would you have needed more than what I said?
Each one, information as to returning late from lunch, that itself was already self-explanatory. You had already reported that you were coming back late from lunch. Same thing with the phone call that extended by your own statement beyond SBA related. No additional documentation or information was needed. In regards to the incident with the 2-hour late show or arrival at work, when you had claimed that it was due to a personal emergency, we did need information and requested information to properly evaluate whether it truly constituted an emergency. And had it did, i.e. if it was a flat tire or medical emergency, those are something, information certainly would be applicable and relevant in considering whether or not to charge that as AWOL. But at that time, after multiple requests, we were not provided any information or context to evaluate that particular incident, which led us to then evaluate the totality of the 4 instances that occurred over a 2-week period.
Okay, so you are saying that the AWOL determinations, the 4 AWOL determinations were made on the single, based on that single instance where I said that I had a personal emergency, but I did not give you insight into why I had, what constituted a personal emergency. Is that what your assessment of the situation?
Objection, that characterizes prior testimony.
I'm doing the same.
Can I ask you, Mr. Shen, to scroll down to page number 47, please?
Okay.
Okay, and this is a July 25th, 2020 email for me to Mr. Goodson, and you are also CC'd in those emails.
Was there a particular slide number you needed me to look at through?
No, I just wanted to make sure that you remembered those emails, and I want to see if maybe on page 48 you look at the list of attachments that are added, and I wanted to ask you whether, based on the amount of information I provided and the research that I have done, why it was not sufficient for you to, approve my leave request.
I can't speak to Mr. Goodson. This email that you're directing me to was directed to Mr. Goodson after I had already denied your request on appeal. And so I can't speak to, again, Mr. Goodson's evaluation of any documentation that you had attached to this email, as it was directed to him, not me.
Okay.
I was not in a position to make a decision on this, as I had already previously rendered mine.
Okay. And during my during this time period was is it your belief? Would you agree that my performance was still being measured by my supervisors? Instead I was on.
Objection, relevance.
I'm sorry.
I'll allow it. Mr. Chung, you can answer.
Can you restate that? I didn't understand the question.
During the time that I was appealing my leave, the denial of my leave request, would you know whether my performance was still being evaluated by my supervisors?
The department evaluates performance continuously of all employees. We distinctly treat conduct separate from performance. We can have a very high-performing employee with conduct issues, or we can have an employee with conduct issues, with no conduct issues that are struggling with performance. And so the two are not separate. they are separate in the sense that when we evaluate it, so we could be looking at or making a decision as to a conduct issue or time and attendance issue, does not prevent or does not mean that we're not continuing to monitor and evaluate performance by all of our staff, as it ultimately impacts the service we deliver to the customers we are serving.
Okay. I would like to ask you then, would it not be me maybe being trying to be a good employee by putting off looking through, assembling those 23 or so attachments until, say, a weekend when work is slow, a little slower than usual, instead of having my performance suffer during the week?
Objection, relevance.
Sustained. So he's already answered that he had already rendered his decision at this point, Ms. Kouemo, so it wouldn't be up to him to evaluate how you put this documents together or how that may have factored into anybody else's thinking.
Okay, Mr. Chan, if you please go to page number 57.
Okay.
And keep scrolling down. You can look through the emails and just keep scrolling down. And if you get to page number 60.
60.
Yes. And you can also keep scrolling down if you wish, but I just want to point out to the page 60 and page 61. And as you can see at the top of page of those pages, it says forward request for reconsideration of denied leave. And would you confirm that based on these documents that you did in fact receive this email that explained that I was on a virtual, that I was that I communicated with my colleagues in another office regarding these matters, the EID loans reconsideration?
Yes, I was aware. I did see that particular email, which evidence you were on that call, but that in of itself did not explain by your own admission and your own statement in email that what again started off regarding SBA related matter in your email. You indicated that after the topic discussed in the email you just referred me to, after that topic had been discussed, it then veered off into other things, and that the person that you were on the call with had to tell you that this was not agency time and you can't claim it as agency regular time. And that's the information I reviewed and based my opinion in part on.
Okay, thank you, Mr. Shan. Can I ask you please, actually, I think I'm done asking questions to Mr. Shan. I just lost my train of thought about the next question I want to ask, but that's fine.
Okay. All right. So, Ms. Landry, is there any recross from the agency?
No, Your Honor, no recross.
All right, Mr. Chung, we do appreciate your testimony here today. Please don't discuss your testimony with anyone who is not now present until this hearing is concluded, which will be sometime later today. You are released and you may exit the meeting. Thank you so much.
Thank you. Have a good day.